The problem with the current system is that the moment you've been in the US unlawfully for more than 1 year, the moment you leave, you trigger a 10-year bar from returning to the US. Hello everybody, this is Puyan Darian, an immigration attorney based out of New York, here to talk to you today about President Biden's new immigration program. We're going to be discussing who can benefit from applying for this program, what the procedure looks like, and go through some common questions that we've received about this program. This program is mainly designed to benefit spouses of US citizens who entered the United States without authorization. So that would mean that they entered through the border without really seeing any immigration officer. This would also benefit their children and stepchildren who are in the US without authorization. This program is meant to be an alternative to a system right now which requires for the undocumented spouses to leave the United States, consular process, and re-enter the US after attending a consulate interview. The problem with the current system is that the moment you've been in the US unlawfully for more than 1 year, the moment you leave, you trigger a 10-year bar from returning to the US. So before you leave, you have to apply for an unlawful presence waiver. However, to be qualified for an unlawful presence waiver, you need to show that you have a spouse or a parent who is a resident or citizen, and that this qualifying family member will suffer extreme hardship if you're not allowed to re-enter the US after you attend your interview. Basically, you would need to show that your spouse or parent would suffer more hardship than a normal spouse or parent who is losing you to deportation. This program would, in effect, fix your unlawful entry into the United States. It would be as though you entered the US legally. And those who've entered the US legally, with some exceptions, who are later married to US citizens, can apply for permanent residence from within the United States. They don't need to leave. And the process is called adjustment of status. So what this new program does, it allows you to apply for parole-in-place. Parole-in-place is a legal fiction that basically just fixes your unlawful entry, and it'll be as though you entered the US with authorization when you initially entered. And this will now allow you to apply for adjustment of status inside the United States without ever leaving the US. This will help dramatically by reducing instances of family separation, the uncertainty associated with applying for a 601A waiver to waive that unlawful presence, so you don't need to show any extreme hardship to your spouse or parent. And it'll allow you to apply for employment authorization while your case is pending. Okay, so what are the actual requirements for this program? There are basically 4 requirements that we are aware of right now. The Federal Register hasn't been issued, so the exact regulations and policies are not out yet. But what we know so far is that you must have been in the US for at least 10 years as of June 17th, 2024. So you must have entered by June 17th, 2014. And as of June 17th, 2024, you must have been married to a US citizen. So if you get married after that date, that's not good enough. If you're married before that date, you probably qualify. If you married before that date but later divorced, I don't know yet. We don't exactly have all the rules, but my guess and intuition on this is that you would need to be married to a US citizen on that day. So I would guess you wouldn't qualify. There are 2 other major requirements. Number 1, you can't have any significant criminal history. We don't know exactly what that means. There are some crimes that render you inadmissible or deportable, but usually when a discretionary program like this is created, they just create their own set of rules for which crimes would render you ineligible for the program. If we think back to when DACA was created by President Obama, they basically said you can't have more than 3 misdemeanors and not more than 1 significant misdemeanor. An example of this would be a DUI. For DACA applicants, 1 DUI would disqualify you, but outside of the DACA context, One DUI in New York usually doesn't render you ineligible for immigration benefits, so they kind of just created their own rules. It's interesting to see what they're going to do with this program. I'm curious to see if they're going to just mimic the same rules for DACA. The other and final requirement is that you must have entered the United States without inspection. So there are two things that come to mind here. Number one, if you entered with a visa, you probably don't need this program because you already have proof of lawful inspection. And if you're married to a US citizen, you can probably already apply for permanent residence. The second thing that comes to mind is crew members. So people who entered on the C1 visa as crew members are ineligible to apply for adjustment of status. And my guess at this point, based on everything I've read, is that those crew members will remain ineligible because one of the requirements is that you must have entered without inspection and without a valid visa. How is this program going to work? Well, the first step will be to fix the unlawful entry, and that's going to be done through something called parole-in-place. The Biden administration has suggested that applications for this will be rolling out towards the end of summer. So the way it'll probably work is we will have to submit an application applying for parole in place with evidence that you have a US citizen spouse as of June 17th, 2024, that you've been in the US since that time, you have no serious criminal history, and that you merit a favorable exercise of discretion. Generally, we want to show that you're a good person. This can be a bunch of things, paying taxes, which would also prove that you've been here continuously for those 10 years. After we submit the application, we would probably wait a few months for it to get approved. If there's a massive influx of applications, it could take longer than that. There is a parallel system right now for military service member family members. For example, if you are the family member of someone in the military, you can apply for something called military parole in place. And currently that process takes like 4 months from when you apply until it gets approved and your unlawful entry is fixed. After you've fixed your unlawful entry by being granted parole in place, we would then submit a family petition and application for adjustment of status, and if you choose, we could also apply for employment authorization at the same time. One question that I've received is, what if you've already filed an I-130 family petition in the past and it's been approved? Well, we actually might be able to salvage it based on my understanding of the process. You certainly won't be prohibited from applying for this if you've submitted a previous I-130 family petition. Another question I've received is regarding the stepchildren and children of the undocumented adult who's married to a US citizen. The Biden administration has told us that stepchildren and children will be included and that as many as 50,000 people will be able to apply as children and stepchildren of these parole in place parents. The kids will also be granted parole in place so long as the child or stepchild relationship was in existence as of the 17th of June 2024. A child or stepchild relationship is created so long as the parent is married to the US citizen before the child reached the age of 18. For immigration purposes, these kids would be children or stepchildren and would be able to benefit from this program. Alright guys, so that brings us to the end of today's video. If you've been in the US for more than 10 years and you were married to a US citizen on June 17th and you want to consult about applying for this program, you can schedule a consultation directly with me. I handle these cases throughout the entire United States. Consultations can be done by video, telephone, or if you're in the New York area, you could always stop by and we can do it in person. You can find the information in the video description below, or you can go to my website or give us a call if you're interested in scheduling a consultation. If you're new to my channel, I make a lot of videos on these topics on a weekly basis. In the next 2 weeks alone, I'm going to be releasing videos on how this new program affects people who've applied for DACA, and another video specifically on who is ineligible to apply for this program. And as more information becomes available, for example, which crimes will disqualify people from applying, I'm going to be making videos on those topics. Aside from that, I generally talk about the permanent residence and naturalization process, and I focus my practice entirely on family-based immigration. So thanks for watching, and I'll see you guys next week for another one.